Welcome back to Planning in Practice. We are here again with estate planning attorney John Hannon. Again, very esteemed, highly sought after estate planning attorney here in Orange County. And John is here today to talk to us just about a recent case that he's going through, and he'd like to talk about that and explore some options for how to maybe avoid this in the future. So, John.
Yeah, great. Well, thanks for having me.
Yeah.
Glad we get to talk. Always like talking with you. I was working on a demand letter, let's call it, from a beneficiary to a trustee, and I think these kind of scenarios, I see them often, and it makes me think about, maybe the trust administration or the planning side of things, and what maybe could have been done differently. But in this scenario, essentially, you had dad, and he had several kids, and he got remarried and had a second wife. He passed away, and we don't know what the plan was, right? Our client's one of the children, and we don't know what the plan was. And so we believe that the stepmom became trustee, but our client, since dad passed away, has not received any trust instruments, hasn't received any accounting, hasn't received any financials, and was really just in the dark about everything.
Yeah.
And so, not just this particular case, but in general, I think that makes me think about, when you are administering a trust and you are the trustee of a trust, you have what's called a fiduciary duty, right? You're aware of this.
Yeah.
Fiduciary duty, highest standard under the law. And the idea is that trustee has all these duties owed to the beneficiaries. When the trust is irrevocable, those duties are owed to the beneficiaries of the trust. When the trust is revocable, it's going to be owed to the creators of the trust. But when those duties become really important is when the trust is irrevocable. And so one is identifying who are the beneficiaries.
Sure.
So we, again, in my example, assume it's our client. But the trustee needs to know to whom is the duty owed, and what are the rules involved. So one is going to be read the trust.
Yeah.
Right? Know what it says. And it's very likely that trust says, as soon as this trust becomes irrevocable, you need to let all the beneficiaries know.
Yeah.
Now, there are some trusts from other jurisdictions that are called silent trusts that the beneficiary maybe doesn't have to know.
Okay.
I'm not practicing in those jurisdictions. I'm practicing California. So in California wants the beneficiaries to know
Yes.
as soon as possible, and wants them to know a lot. And so included in that's going to be an accounting where you basically do every single transaction that the trustee has performed. And so what I see a lot, because maybe some of your clients, they're the ones who created the trust, right? Maybe they're not administering it, but people are going to come involved. They're going to come around trust administrations, right? Maybe not for their own passing, but maybe for a sibling or for their parents, and they're going to come around it. And what I see is there were certain things that the trustee could have done to avoid a blow up, not only them getting sued, but also with the family dynamics just dissolving, right?
Yeah.
And so some of those is just, you got to keep the beneficiaries informed. Okay, so in California law, there is a duty to account to the current beneficiaries, but more than that, there is a duty to provide information. That is intended to be very broad.
Yes.
If you're a beneficiary,
for that reason.
you get to ask, and the trustees basically got to give you that information, right?
Sure.
What are the accounts? Give me statements, all this stuff.
Yeah.
And so one of the biggest reasons I see that leads into trust litigation is a lack of information provided to the beneficiaries. They feel in the dark.
Yeah, so I want to interject here. So I've had a couple of clients that have exactly that had happened. A beneficiary comes in and says, "Hey, my mom passed. I need to know all the account information," and I have to stop and say, "I cannot give you that information. I don't have the legal paperwork to do so." It is actually more of a common thing that we see all the time. Like, I cannot give you out any financial information. You gotta go through the trustee.
Yeah, exactly. And so, it's the trustee's duty. They're the ones who need to provide the information. And lack of providing that information can cause beneficiaries to feel like they're in the dark. They don't know what's going on. Even if the trustee is doing a great job, even if they are meeting with you, even if they're meeting with the CPA, an attorney, if they're not sending out communications to the beneficiaries, they can get suspicious.
Yeah.
Right? And so I see all the time, it's just a lack of communicating with the beneficiaries can just lead to, all right, now that trustee is going to get a demand letter
Yeah.
from an attorney saying, we need to know all the information, and if you don't provide it in 30 days, we're going to file something with the court and have you removed,
Yeah.
and then surcharge. And it's like, oh my gosh, that's a really scary letter to get as a trustee, and it could have been void. So typically with my trust administrations, when I'm representing trustee, the first thing we do is we'll send out this notice, and with the notice will be a letter that says, here's what you can expect for the next year.
Yeah.
Right? There are things like estate tax returns. There are things like income tax returns. We have to get appraisals to value the assets to determine whether we need certain types of tax returns. And so just setting the table, giving people expectations is gonna make the beneficiaries feel like, okay, I'm not in the dark.
Yeah.
Right? I know kind of what's going on.
Absolutely.
And it's the same thing, right? The trustee was going to do maybe the same thing. It's just setting the expectations.
Yeah.
Right? A lot of times I try to set those expectations of, hey, beneficiary, there's certain time limits. If there is an estate tax return, probably not going to be filed until 15 months after date of death. So don't expect a check
Sure.
for a year and a half.
Sure.
Right? And then that's going to change over because once beneficiaries find, oh, somebody passed away, they've already spent the money. They thought about what they're going to spend it on.
Yes.
They may be, I've seen it, they're already in escrow.
Yeah.
Like, why are you in escrow? Nobody said you're going to get a check already.
Yeah.
And so, people's natural reaction is just think, I can get a check immediately. No, but there are steps you need to go through.
Right.
Notices to different government agencies.
And nothing happens overnight.
Yeah, exactly. And so, that's a big part of it is just keeping the beneficiaries informed, setting the expectations, and then keeping really good records in case you do need to provide an accounting. Sometimes beneficiaries can waive it, but beneficiaries are entitled to an accounting.
Yeah.
So I've seen it where the trustee goes of several years, and then we say, okay, time for an accounting. You're getting an accounting request. They can't do it.
Yeah.
There's too many accounts all over the place.
Sure.
They haven't kept track of things. They commingled. I've seen all sorts of commingling.
Oh, man.
Paying for personal groceries, paying for something. And even if you created the accounting, if you start seeing personal groceries on there, beneficiaries are very unhappy with that. So if you make mistakes, correct them immediately and then don't make them moving forward. But that's why you need to have, the planner involved, attorney involved, CPA involved to kind of say, what is the story you're going to have to tell somebody one day in that accounting?
Yeah.
Right? And if that story is not a good story on paper, you might have to have a problem or figure out how you're going to explain it. Because most trustees aren't doing a bad job.
Yeah.
Most trustees are trying to do the best they can.
Yeah.
A lot of times trustees are also beneficiaries.
Sure.
And so they want the money too.
Yeah.
Right?
Yeah. And you mentioned earlier too, trustees, they do their best, but most of them don't have a legal background. So they're not exactly sure. And having you set the expectation of what beneficiaries can expect makes the family dynamic easier. Because you alluded this earlier, there's trustees that do a very good job, but there's other family members that may have already spent that money. Well, I need it now. And then you had a relationship between a brother and sister, or brother and brother siblings that was good, but now it's incredibly strained because they're in the dark or because they don't know how this process works. Yeah. And it can really mess with family dynamics.
Yeah, and you talk about, not knowing how the process works. There's certain things that you as a person intuitively, why can't I do this? I can just do it.
Sure.
So for somebody, there's a beneficiary, your sibling, and they need some money really quick just because there's a certain issue. And they need some funds really quick. And you think as a normal person, oh, well, I'll just give them the money or lend the money from the trust. You have to treat the beneficiaries equally. Right? There's a duty of impartiality that the trustee has. Have to treat all the beneficiaries equally. So if someone has that scenario for me, and they say, well, there's one sibling needs $90,000. I say, well, we can do that, but how do we do it where we keep all the beneficiaries equal? We either pay everybody $90,000, right? Or we get everyone's consent that they get an early distribution and they don't. Yeah. But now that sibling, who you have to go and say, hey, we're going to tell everybody the plan. Oh, maybe I don't want the $90,000 because I don't want to rock the boat,
second
right?
thought,
Right. But those are the kind of things where there's certain things that on a personal level, on a family dynamic level, you want to do. Yeah. And you feel like I should be able to do that. You may be able to do that if we make sure we're complying with the duties. Yeah. But if you do something, and I saw this, there was one trustee giving large amounts of money to the one child that everybody knew needed it.
Mm-hmm.
But they did it without asking the attorney. And so when we're providing the accounting, it's like, well, what is that?
Yeah.
Is that a loan? Is that payment for services? Is that an early distribution?
Yeah.
What is it? And then you have grant. It's not typically the bloodline who has the problem. It's the in-laws.
Yeah.
They're it's going to be
yeah.
the in-laws who are ghostwriting emails.
Yes.
It's the in-laws who are, I got called from an in-law once, and she's very, very upset. And she says, well, my husband hasn't even read the documents we provided, but I have a lot of problems. And
of course you do.
She's going to have a lot of problems.
Yeah.
Right? So a lot of times, even if you think that all of the siblings are going to get along, and a lot of people will say, we're a great family, all the siblings get along.
Oh,
but what about the in-laws?
Yes.
Right? And so you have to take all that in consideration, which is why I think, setting the table, setting the expectations,
Yes.
Communicating clearly, doing accountings on an annual basis. If this administration has to go a couple of years, not waiting 3 years to do a super accounting, we'll do it every year.
Yeah.
Right.
Yeah, absolutely. So communication, obviously very important.
Mm-hmm.
So for someone who may be watching this video that's in this situation or knows someone that's in a situation where, there is one trustee and they're not happy, what would you recommend?
Yeah, so I think from a few levels. One is just as a planning side. When the settlors, the creators of the trust, think about who to pick as a trustee, that's one of the most important decisions. And sometimes people will just, my firstborn.
Yeah.
Okay, but maybe they don't have a financial background. Maybe they don't have the temperament to handle people,
Right.
Having difficulties and asking questions.
Right.
So that becomes a really important question. And some people will just kind of punt it and say, I pick all of my children to serve equally. It's like, well, you've just given your kids a group project.
Yeah.
We'll see how that goes.
Yeah. Because they all have to agree.
Yeah, and it just from even a simple banking perspective, if you have 4 children as co-trustees, you're going to have 4 signatures on that check. And there's some banks who won't even do that.
Yeah.
Then you go into specialty banking now.
Yeah.
Okay, so that's why there are professional trustees. And so for some clients, I say, hey, because of your family, the best thing you can do is to have this person, this professional trustee or corporate trustee, serve as the trustee to preserve the family dynamics.
Yeah.
Right?
Absolutely.
Maybe the cost of paying that person is worth preserving your family dynamics.
Yes.
So that's a first preliminary just planning point. But if someone's in a situation where, the trustee is not providing information, right? That comes down to, one, the beneficiaries. If you're a current beneficiary, and even, depending on the language of the trust, some contingent remainder beneficiaries you should be able to request information, right? And I would always encourage like a soft request, right? This is my personality.
Yes.
I'm trying not to get in litigation. So a soft request, hey, this provision of trust says I'm supposed to get information. Could you just let me know what's going on?
Yeah.
Can I get a status update? Because once you involve the attorney sending a demand letter, it starts to escalate it, right? And so sometimes the trustee will well, now I don't want to provide anything.
Right.
And they'll try to freeze up, right? So trying to take it in stages, right? Taking a step. You don't need to first send out, file a petition for trustee removal and surcharge, right? So try to just see, maybe they just, they're trying to do a good job and they just forgot because there's a lot going on to just give a status update. So I'd say that first. And then on the other side, if you're a trustee, you just got to keep giving information to everybody.
Yeah.
Simple email status updates go a long way to let everybody know, not feel left in the dark.
Sure.
And then also on major decisions, selling a property, selling a business, let people be involved. Say, hey, I'm thinking about doing this. I'm going to hire a realtor, so it's going to go on the market. Any problems with that?
Right.
You were going to do it anyway.
Right.
But it makes people feel like they're involved.
Yeah.
And then also the trustee has certain tools.
Yeah.
Right? They have what's called a notice of proposed action. They have what's called a written consent. These are legal ways that they can do certain large actions. And if, certain things are met, they can't get sued by the beneficiaries later.
Yeah.
Right? So that's trustees are going to know that. Right? So that's why my goal is to try to, when I represent trustees, protect them from liability and try to, mitigate that liability and use some of those tools, set the table with communications to the beneficiaries.
Yeah.
Provide information, provide accountings, all that.
Yeah.
Because on a personal level, I want families to stay whole. I don't like to see mom and dad passing away and then the siblings never talk to each other again.
I can't tell you the amount of times I've seen that where siblings come in and even before while the parents are alive, that their siblings are getting along, but as soon as the parents go, I need my money now, or like you said, it's the in-laws. You get on them because we need that money because I need this car. We want to go on this vacation. Even the best knit, tightly together families still feel friction when it comes to that. But communication, proper planning, it really can. And most importantly, I think you said it too, setting the proper expectations is going to make it easier on the family and the person who is the trustee, which sometimes, they, like you said, they may not have asked for it or may not be the most capable person. They may have just been the oldest or the one who mom talked to last. So keep that in mind, when people are doing trusts, and there's a lot of moving parts.
Yeah.
So John, thank you so much for coming. This has been another discussion here on planning in practice. And before we go, John, for people who are watching this, if they want to get in touch with you, how would they go about doing that?
Yeah, sure. Again, my name is John Hannon, estate planning, trust administration, tax attorney. Our office is in Irvine. I'm with law firm Murtaugh. So you can look us up on Murtaugh Law, or you can ask Grant and he can connect you with me.
Yes, I'd be happy to do that. John, thank you so much.
Thanks, Grant.
Thanks, guys. We'll speak soon.